Okay, we're back for the second part of our lecture. And we want to talk about the permit process. So, the Clean Water Act um, covers waters of the United States from a point source. And how the Clean Water Act works is that if you are going to discharge into a water of the United States from a point source, you have to get a permit. And it's usually issued by the EPA. Sometimes the state and the EPA have some sort of an arrangement um, where the state has their own permit process approved by the EPA, and then it would be a state permit. So usually, actually, it is typically issued by the states, and that was kind of one of the problems in Flint was that the state did not do a good job with their enforcement and their water quality stuff. But anywho, so the requirement in of the states is that they must have at least as many restrictions as the federal. So they cannot be like more lenient than the federal under their permits. They can be more restrictive. Okay, so these permits are designed to establish effluent limitations, okay, limitations that are appropriate to the activity being proposed and are enforceable by the agency. So, what can they let flow into these waters? All right, so I talked a minute ago about, the expense of getting these permits and the cost of getting these permits. Part of the reason is because it's a 7-stage process. So, first, there is an application, there's a form, fancy form, and it must be signed by a responsible corporate officer. So whoever, it can't just be some jamoke in the mailroom. It has to be somebody who's kind of an officer of the corporation. Okay, then so they sign a certification that it is, true and accurate what they're doing. So the person who is making this application sometimes, has a little committee talking about it because it's not, their name is on the line to certify that this is the truth. So they do their due diligence, or they should, to make sure that what is in the application is true before they sign. And that is, the application must be made at least 180 days prior to when they plan this proposed discharge, or before the 180 days before the expiration of an existing permit. Um, and a permit is required, when there's a new discharge, or if there's like some sort of a change in quantity or type of discharge that is happening. Okay, so then the next process is certification by the state. The the state will certify that these proposed permit conditions comply with all of the federal requirements, including their limitations, water quality standards, everything that is required under the Clean Water Act. That's, if it's a state thing, if the state is doing it. And if the state doesn't do anything within 60 days, then the state is deemed to have waived its certification and they can kind of go ahead with the next one. So the next step is releasing these permit applications to the public so that they have notice of what is proposed, and the documents that are released to the public are a fact sheet or a statement of basis for the permit request. And there's usually a draft permit or some sort of, if they're thinking about denying the permit, there's an intent to deny. So that then all of this is released to the public, and then there is an opportunity for the public to comment. So they can file a written comment on this proposed permit. After about 30 days, there is an informal hearing in the public where they can, voice further concerns about the permit if they have them. So that's kind of, remember we talked about environmental discrimination and environmental racism. So this is an opportunity for the public to get their position out there. Okay, so then in stage 5, the state or the EPA, depending on who is issuing this permit, they decide whether they're going to issue the permit or deny the permit. If the permit is issued, its effective date is 30 days after they issue the permit, and it's usually 5 years for how long it is valid. Okay, and then that is called a final permit. If if you are a resident or a concerned person, after this final permit is issued, they can request an agency, an administrative law judge evidentiary hearing on the issuance of the permit. Okay, so this would be stage 6, only if requested by someone, and they must do so within 30 days of the issuance of the final permit, right? Because it's going to go into effect in 30 days. And they have to, tell all the reasons, legal and factual, that they're basing this appeal on. And so you have 30 days to request it, and then the agency must either have a hearing, or grant the request for the hearing, or deny the request for hearing within 30 days of that. If you have a hearing, it's not informal. It's more like a trial. There's like rules of evidence, and there's testimony and documents, and there's a judge who makes the decision. And then that decision may be appealed within 30 days to the Environmental Appeals Board, which is part of the EPA. And then after that appeal to the Environmental Appeals Board, then they call that a final agency action. And then you can appeal a final agency action to the Federal Court of Appeals. So for us, it would be the Seventh Circuit. And, so that can go on forever. But, the court is going to pretty much uphold the issuance of the permit unless there was an arbitrary and capricious decision, or abuse of discretion, if they acted carelessly, or somehow violating the Constitution, somehow legally inappropriate. Otherwise, that will be allowed to stand. Oh, look at this! It's all I talked about this. Okay, so. All right, so the application, and then certification by the state, or they can just kind of let it happen, like a pocket veto kind of thing, right? Just let it, if they don't do anything within 60 days, it's certified. Then we give these documents to the public. Then we have the public hearing. And then the state or the EPA decides whether or not they're going to issue this permit. It's called the final permit. And then an individual or a entity can request a hearing. So, right, optional step. There's 2 optional steps. So 5 real steps, 2 optional steps, but it is a 7-step process, and it's time consuming and expensive, as we learned in that other case decision we were looking at. So permit conditions. One of the things that a permit does is it establishes not imitations, limitations. That's funny. Limitations. Silly. So what does effluent mean? Effluent is like what's flowing into the water. I'll give you the dictionary meaning. Flowing out or forth, something that flows out. So, we're thinking of a pipe or a canal, or like a gutter, right? So that whatever's flowing into that is the effluent, what is flowing out into the water. and they permits say how much of this effluent you can discharge into the water that you're talking about. And it has to be appropriate for the activity of the water that you're going into. And these permits are enforceable. Okay, so the EPA has created these effluent guidelines uh, that nationally have to be applied. And so, depending on the categories of what you're putting into the water, and the types of dischargers and things like that, there are different technology based standards of what you have to do before, how you have to treat the water before you discharge it into this water of the United States that we're talking about. So these are the different levels. The lowest level of treatment, we'll call it, is best practicable technology. So maybe it's a filter, right? Or maybe it's adding, chlorine or something along that, right? I don't know what it is, but that's best practicable technology, something minimum level of required treatment. Okay, then step up is this best conventional technology. So those are conventional pollutants, so kind of like non-toxic. So, maybe wastewater or household discharge or something like that. Okay, then best available technology, next highest one, that's toxic and non-conventional pollutants. So think of real toxic waste, or maybe industrial type cleaners or lubricants or something like that. And then these are worse ones. For worse toxic and non-conventional pollutants, you have best available demonstrated technology, so the best you can do. Okay, so it's just the level of treatment that you have to give to the water before you can discharge it into this water of the United States. Okay, if we don't have a guideline for our type of pollutant, the EPA uses what they call BPJ, best professional judgment. So it's kind of in the EPA's judgment. So they look at the type of discharge, see how much is being put in there, what's the location, any other kinds of considerations before they come up with the technology for it. So we have a permit. And then if you are, either asking for a brand new permit, or you're asking to change your permit, like increase what you were putting in there are what we call new source performance standards. Okay, so those are for any kind of new permit, and we have that's the highest one, that best available demonstrated control technology. It's a higher standard. And so if you're already discharging and maybe you're just like modifying your permit, like you kind of want it to be, you don't want to have to do more work or more treatment, because that will be more expensive for your corporation. So a lot of companies challenge being categorized as a new source a new source discharge. Dischargers can say, like, I don't like the standard, it's too much, I can't afford to pay this, I don't know how to use I can't use this technology. I can get a variance. It's hard to get, but one of the common, if you do get one, the fundamentally different factor variant, it's if the factors determining the technology standard, whatever the standard, are fundamentally different to the factors considered when they created these limitation guidelines. So if things are like way different than when the guidelines came out, we look to this fundamentally different factor variance. So they look to, what's the type of pollutant? Is it toxic? Is it not? Is it carcinogenic? how big the volume of the discharge, um, environmental impacts, not just to the water, but to the environment around it. What's the requirement of these treatment technologies? So maybe it will add a strain to the environment in a different way. And then they look at the facility itself and see how efficient it is. Okay, so in 1987, the Water Quality Act was passed. So it's kind of like a furtherance of the Clean Water Act. And part of what came with the Water Quality Act are water quality standards. So the states are allowed, individual states are allowed to set their own water quality standards. Okay, they classify the purpose of the water. Is it, drinking water? Obviously, then you would have a higher standard of quality for the water. Is it, for swimming? That would be a pretty high one. But if it's people fish in the area, that's a higher one. But if it's just, for barges and commercial boat traffic, maybe not as high a water quality standard. Okay, so the criteria for the state to set their own water quality standards comes from this Water Quality Act of 1987. So they, figure out what do we need in drinking water. And that comes from the EPA usually. And then in that drinking water, you'll have maximum levels of certain pollutants, like how much lead can you have in the water without it being harmful. Um, and then they have these formulas. It's all math to reach this total maximum daily load, which is TMDL, of a body that a body of water can withstand to meet this water quality criteria, right? So to keep the lead down to zero point zero 0.05 per liter. I'm just making that up. How much lead can be discharged into that lake per day? And then from there, they have to analyze all of our waters in our state, and they have a list of what we call impaired waters. And there are, there's for these impaired waters, they have higher standards of what can be discharged into them. A lot of these impaired waters will never meet your state water quality standards. So this is just a website with our list of our impaired. Where's our? Oh, I want current ones. List of impaired waters, and information about the TMDL, right? Total maximum daily load process in Illinois. So is this this is my list. Oh, not that one. That's something. Oh, poop. That's not what I want either. This is what I want. Okay, so they'll tell you, that this is Illinois, the name of the water, the designated uses, and the problems. Okay, so this one has mercury. This one has phosphorus. Dozer Creek. Is there anything? Let's try the Chicago River. Okay, so the purpose: fish consumption. People fish there and eat the fish out of it. They have DDT, right? That's a pesticide. Mercury, all sorts of crazy things. So these are our impaired waters and what they're polluted with. Kind of crazy. Schiller Pond. I don't really know what's around here, but that's something. DuPage River, that's near me. Things that they have there. So that's just an interesting thing for you to look at to see what's impaired near you. These permits require, so I have a permit to discharge effluent into a body of water. And so I have to then test this water for toxicity. And depending on the permit, it might be weekly, it might be monthly, it might be annually. I don't know. The frequency and the reporting of the toxicity testing varies depending upon each permit. Um, so, the Clean Water Act only concentrates on point sources, right? We talked about point sources, 1 point of discharge. Water Quality Act expands that to require the EPA to issue regulations for stormwater discharges, right? So, you have if there's a big rain and there's stormwater, like where is that going to go? And what effect is that going to have? So and that applies to areas with industrial activity and municipal storm sewer systems that serve over 100,000 people. So pretty much where we all live. So, there's sewers overflow in cases of storms, and, how's that going to affect things? So the towns or the municipalities are going to need a permit for stormwater discharges. So do you know that this happens? Like, um, we have a big storm, and then stormwater and sewer water is discharged into Lake Michigan, and then you can't swim in the lake for a couple of weeks after because of E. coli or whatever is in there. And so the municipalities are going to have a permit for these stormwater discharges into whatever body it is, the Des Plaines River, the DuPage River, wherever it goes. And the Water Quality Act, which again is from 1987, sets application procedure for the permits for stormwater discharges. So stormwater discharges, right? It comes from all these sewers. So it's not a point source type discharge, which is covered by the Clean Water Act. So this kind of expands the discharge to not just point source. Sea and ocean discharges, there's two ways that we regulate that. There is a permit that may be issued if whatever you're discharging won't result in an unreasonable degradation to the marine environment. And then, but there's another one. So there's two kind of laws. There's also the Marine Protection Research and Sanctuaries Act that says all you can dump into the ocean is dredged soil. You may remember there was a case about oil leases, and they were concerned about dumping the dredged soil into either the ocean or into other waterways, because then the other waterways, you get salt water in there and you can wreck the environment for the wildlife. Okay, so non-point source like wastewater and street runoff, the Water Quality Act provides. So it defers to the state for non-point source water pollution. And the states have to submit their own programs to the EPA. So they have to say, this is what we're doing about non-point source discharge, and we submit that to the EPA, and they approve your plan. Okay, spills are always going to happen. Under the permit program, the Clean Water Act requires a lot of these dischargers to develop these spill prevention, control, and countermeasure plans. So it's like, what happened? Worst case scenario, something bad happens. What do we do? They have to be certified by an engineer and updated, and the EPA has to approve this as part of the permitting process. And if there is a spill, something happens, you have to report that to the National Response Center. So how is the Clean Water Act enforced? There's, as you saw for the Rapinos case, right, there are pretty severe civil and potentially criminal penalties. You can have either the state EPA or the federal EPA can bring a lawsuit against someone who is violating Clean Water Act requirements. a lot of times they'll just get an administrative order from, whatever, the state EPA that says you have to comply, or you're going to lose your permit or get fined. So think about Mr. Rapinos. He put some sand in a hole, and they started fining him and threatening him with jail time. Or they can sue you, right? And from that lawsuit, they can assess fines. You can request an injunction that can be imposed. And if it gets real bad, they can give you criminal fines or even give you prison time, like Mr. Rapinos. He had, what did he have? Community service. And then I think I don't know if he ever served jail time, but he was sentenced to jail. I think they let him stay home pending the appeal. So you have civil, criminal, administrative remedies to enforce the Clean Water Act. Okay, that's the Clean Water Act. And I'm going to stop, and we'll talk about the other two in the next video.